Hey, it's 1:01. Sorry, I'm a minute late. Yes, I am back. Hope everybody got their answers from Lauren regarding admin questions. And we're in the middle of talking about transfer of title. So I'm going to moderate the conversation and proceed with the lesson plan. So, title, as we discussed, can be transferred during a lifetime either voluntarily or involuntarily. Voluntary examples of a voluntary transfer of ownership would be through the sale of property, a gift of property to someone. You could also lose your property through an involuntary action, such as foreclosure. You didn't pay your mortgage, so the bank took your property. Or through tax foreclosure, you didn't pay your taxes, the town sold your property. And you didn't have any control of that. Those are involuntary examples of how transfer of title happens without your permission. Other ways to involuntarily take or to lose your property would be through eminent domain, an act of government through courts known as condemnation to take your property for a just public good and offer you compensation. Or, gee, how else can I lose my property? I'm not liking this idea of involuntary alienation. Action by partition, meaning a legal court process, which may remove you from ownership or directly require you to sell the property. So a court action can get rid of your property against your will. And also through something called adverse possession. Now, several days ago, we talked about easements, and one of them was an easement by prescription, where somebody uses your property without your permission or without you telling them no for a minimum 20 years in an open notorious manner for exclusive purpose. They can create an easement by prescription. Well, the same process is used in an adverse possession, meaning someone's using someone else's property without their permission or rejection in an open and notorious manner for the exclusive purpose of doing something. And if they do it, in this case now, for a minimum of 30 years, then they can actually take the property legally from someone else and acquire ownership without paying a nickel. It's a legal stealing of property. What? I want to know more about it. I don't want to raise a bunch of criminals about it. This happens, obviously, believe it or not, more than you know. What? In a certain section of New Jersey known as the Gold Coast, that's the, Palisades from Englewood Cliffs going all the way down to Jersey City or so. That is known as the Gold Coast. Many properties were built in that area, literally on top of each other, literally properties right next to, in front and behind, and it's on a hill. So, man, it's like so many properties. And occasionally a guy puts up a fence or builds up a driveway. It's bigger than it's supposed to be. No one says anything. And before you know it, 30 years goes by, and all of a sudden that person gains control of the property that they're using without the owner agreeing to it. They gain control by taking it from them, adverse possession. So let me just use a little diagram to explain what I'm trying to talk about. So here's two property owners. There's one lot. There's the next lot right next to it. And here's the street out here. Now, this guy's driveway goes across down the side and goes to the back to a garage structure on his property. Over here is the house, etc. You know about these things. In the backyard is here. But anyway, here's the driveway, gets his backyard. Now, previously, the house has been expanded, and literally all the way to the driveway line, this house now takes up the entire area. This guy This guy also has a driveway down the side of his driveway, goes to his backyard to a garage structure, et cetera, et cetera. And his house is over here and fills up the entire lot again. So those two houses are built out and their driveways are very small, but these driveways originally were built to park Model A Fords on them. Very tiny lots and very small driveways. But your neighbor here, he goes out and buys a Cadillac SUV. One of the, we're talking about the Escalades, the big XLTs, a huge monster. And he can't fit in his driveway, so he pours a little bit of a foundation along the side of the property to make sure he has enough room to get his big Escalade into his driveway. And he's really only using, maybe about 2 feet of your property. It's no big deal, right? Well, is it? Did you give him permission? No. So he just took that right to use without your permission. But is that fair to you? Doesn't matter. You didn't say anything, did you? You didn't complain. You didn't give her permission. So now he's got this nice big driveway for his Escalade to get in and out. But your property pretty much ends here, right? Goes this way. Here's your property line. Now, if he's using your part of the driveway, or he's using his driveway on your property, you don't give him permission. You don't tell him, no, you can't do that. And he does it for a minimum of 30 years. He can take that strip of property from you in a legal claim. And now this whole driveway belongs to him. And you just lost 2 feet of your property because you didn't guard it. Guys, when I tell people all the time you should jealously guard your property, I'm serious when I say this. There are people, neighbors of yours, whether you like it or not, that may have nefarious ideas about if. And they accidentally put a fence up 3 feet over your yard. Or because Ma let them use that side patch for planting their roses, you let them continue doing that, but you never say anything. They just keep doing it. Well, if they do it for 30 years in an open and notorious manner, meaning everybody can see what they're doing, everybody knows what they're doing it for a specific purpose, and it's continual in its use. Well, if they do that for a minimum of 30 years, they can take your property from you and you're out of luck. You are surely out of luck. So good heavens, protect your property. If you see someone putting a fence, a building, a structure across property lines, you go over to your neighbor and say, hey, you got to put that back. You're encroaching into my property and that's not allowable. Or if it's temporary, you say, okay, yeah, I tell you what, I'll give you permission, but it's only for a period of 20 days. And then you should write up an agreement and have them sign it. Better yet, all you have to do is post no trespassing signs on your property, or just paint purple paint on the edges of your property, which is the internationally recognized sign of no trespassing. And that is public notice of no trespassing. You can't use my property without my permission, which would stop anybody from attempting to encroach onto your property. So alienation could be involuntary through adverse possession. Was there any questions about adverse possession or voluntary or involuntary alienation during a lifetime? What if you plant a bush? Is that considered encroachment? Could be. What's the difference between a bush and a hedge of roses? What if someone take a government, there is no government property subjective to easement by prescription or adverse possession. In other words, the government makes these rules for private property owners, but it doesn't apply to government-owned land. Just so you know. How do you prove 30 years? Have testimony and evidence of people watching you do it. They'll tell them. Does it get recorded for new survey by then officially thereafter? Yes. What type of documentation do you need to show you did it for 30 years? Again, witness testimonies. And the X you just gave, why is that adverse possession, not easement? It could be either or, Michael. In this case, I'm just illustrating adverse possession. And the fact that you have to do it for 30 years is adverse possession, 20 years, easement by prescription. What the neighbor gave you permission to use, what if the neighbor gave you permission to use 3 feet of their property for your fence? What happens when there are new owners of the house? Well, then you better make sure that they understand that it was only temporary in nature. So you should always have your agreements, believe it or not, in writing. That way you can prove that that agreement was made. Everybody wants to know how to steal property now. Yeah, I just gave you an unclaimed property, get it for free. Now you want to steal it. Good Lord. All right, was there any other questions before I'm about to move on? Would any further agreements be included in a survey? Actually, it would be listed under the deed as a license or a easement. So an easement by prescription can become property. I guess you could say that if you do an easement by prescription, then do it another additional 10 years, then yeah, you could file for adverse possession if no one claims it. I'm painting that purple line. Yeah. It has to be purple. Well, that's the internationally recognized color of no trespassing. You didn't know? I'm sorry, you guys didn't know that? I thought everybody knew that. My mistake if you didn't. This happens a lot in Puerto Rico. People own property because they take it. Happens everywhere. Happens everywhere. What if you just bought the house and the neighbor has been using part of your property for years? Well, then you better tell them you can't do that. And hopefully it wasn't 30 years or more. That's why nobody ever trespassed on Prince's property. Purple rain, baby. Can someone be devious? I'm sure they could. I'm sure anybody can be devious, Robert, but I don't know how that's. Here's the what ifs again, guys. Please stop with the what ifs. Anybody else before I move on? I'm done, says Jesus. Okay, see ya. Was there anybody else not see? Hi, Tim. A deed is valid with no percentages, husband and wife in tenancy. I'm sorry, Julio. What? We're on chapter 20, not 19 anymore. So if you want, address that question after class, and I'll be more than happy to address it. Can someone plant a bush and claim the property after 30 years? Guys, come on. What the what ifs? I said the definition, and it's written in your book, that adverse possession must be a continual, open, and notorious use of property. Meaning you're doing it in daylight. Everybody sees you doing it. You don't have permission, and the owner never said no. And if you do it for 30 years, you can claim ownership of adverse possession. You should contact an attorney to confirm you met all the criteria of adverse possession, and have your attorney claim that property through a quitclaim deed. And if the court agrees, you now own that piece of property. So it must be open and notoriously used. Can't just, like in the middle of the night, plant the bush, move a fence. It's got to be open and notorious. All right, so guys, again, please understand, you just need to know what's in the book, not all the what ifs and the mental acuity of the people doing. You don't need to know all that. You need to know, what is it? How does it apply? And I'll be tested on it. That's all you got to know. All right, so let's move on. So voluntary gift, sale, or exchange. The owner gives a deed, or a will stipulates the ownership is transferred when death, but we're talking about during being alive. So you have to use some kind of deed of conveyance if it's voluntary. If it's not voluntary, then other things happen. When you transfer ownership to a property, to a government, that's called a dedication. If a government transfers public property to a private entity, that's called a public grant. Involuntary, escheat, eminent domain, foreclosure, court action, or adverse possession would be involuntary alienation. But what happens when someone dies? How does property transfer? Well, if you died with a will, it is said that you died testate. If you died without a will, then you died intestate. The person writing the will is called a testator. And when you write up a will, you also name the executor, someone who executes the wishes of the will. If you died intestate without a will, then there's no direction as to what to do with property. So the state creates an administrator through the probate courts, and the state determines then what happens to your property. I don't think you want to go that route. It's no fun. So you have probate proceedings when there is no will. So intestate, you die without a will. The property then passes to the heirs according to the will. However, sometimes people die without a will. And what happens then? Well, if you die without a will, involuntary alienation occurs because the state appoints an administrator through probate court, and then the state of New Jersey creates the will. So whoever's around as heirs gets according to what the state gives. Now, you can avoid all that by just making a will. Every time I sell a house, every time I sell something of value or a commercial property or something, I ask the owner, do you have a will? Not that it's any of my business, but what happens if you die? Is your real estate holdings protected, my friend? Well, if I die, the wife gets everything. Well, do you have a will that stipulates it? No, but she just gets everything. Not necessarily. Under the state laws, your wife may only be entitled to the marital residence. What? Well, what about the love shack and Hackensack that she doesn't know anything about? Who gets that? Well, maybe your Missy gets it. Your Mrs. Your Missy, whatever you want to call her. How do I prevent it? By having a will. But then my wife will know. Then you better not have a love shack. The wife will find out about. She'll kill you twice, guaranteed. So always consult attorneys when you have a question about estate settlements. Always. But again, to prevent problems, always have a will. If you don't, then the state will determine what happens. And here's another kick in the teeth. If you died without a will and there are no legal heirs to the property, then the state must do something called a search by law of descent. They're going to look for children, stepchildren, possibly even grandchildren, mothers, fathers, grandparents, brothers, sisters, nieces, nephews, cousins, aunts, uncles. It's 13 steps the state goes through to try to identify a relative. And if they find someone, they get a letter saying, congratulations, your Uncle Milton just died and you just inherited his estate. Well, that's great. And when you get a notice of inheritance, you're not allowed to deny it, by the way. But in order to take advantage of the inheritance, you have to pay out all associated debt to that thing you're inheriting before you get it. In most cases, it winds up people usually have to sell whatever they're inheriting just to pay off the debts. And then whatever's left over from that is what they actually get from inheritance. So to protect your property from, and by the way, if they can't find an heir, after this process of law of descent search, then the state of New Jersey takes that property, sells it, and keeps the money. Yeah, the state gets the money. What? That's not fair. Well, that's why you need a will. So don't claim it's unfair because you didn't make a will. It's only unfair if you compare. So don't compare. Just make out the will, and you got it made. But always consult an attorney about your rights when property settlements are in question. So that chapter is now over with. Was there any follow-up questions to that chapter? Testator is a person who makes out a will. So if I have an estate I want to leave to my heirs, I am the testator making the will to leave to my kids. The executor is the person named in the will to execute the wishes of the will. Boy, that was easy for me to say. Could you explain public grant Public grant is a dedication. Dedication, again, we talked about all day yesterday and the day before, is a gift of private property to a public entity. You dedicate streets and a development back to the town so the town can service that community with emergency services and such. A gift of public property to a private entity is called a public grant. We grant you this property to use for a specific purpose. Executor is someone under the will that is designed to execute the wishes of the will. The administrators, when you die without a will, and state of New Jersey through probate court appoints the administrator to see what happens with the things and who gets what. Or the government receiving the land is cheap. When you die without a will and they can't find heirs after a law of descent search, they sell the property and keep the proceeds. They may even throw it up on the unclaimedproperty.nj.gov website, and maybe you can find it right now. So I hope you guys found some bonus money instead of winning Powerball last night. You got something out of the deal. But anyway, moving on. So what happens when you inherit a house with $500,000 in debt? Well, in order to get the house, you have to pay off the $500,000 in debt, or you sell the house to pay the debt, and whatever else is left over is what you get. 720. Nice. All right, guys, I do need to move on. We still have another chapter, but I have to pull up the review questions from this chapter first. So for chapter 20 is there. Here we go. Number 1. Well, I'm sorry. First, let me moderate so we can do it. Okay. Title to real estate may be transferred during a person's lifetime by spelling correction error number A in number 1, letter A. Device is devise. The C should be an S. Devise. And it does make a difference. Title to real estate may be transferred during a person's lifetime by, during a person's lifetime. By what method? Well, you guys are still coming back from lunch just now. Wow. Guys, please, we start at 1 o'clock, not at 1:24. You guys missed a whole chapter. So from those who did respond, 48% of you are correct. It is C, involuntary alienation. Descent is the law of descent search if you died without a will. Escheat is when they search and can't find anybody and keep the property, sell it, and keep the money when you're dead. Devise, as I said, the spelling correction, is a will, which is only used when you're dead. Therefore, involuntary alienation by process of elimination was the only answer that was left. Number 2, title to an owner's real estate can be transferred at the death of the owner by which of the following documents? Outstanding. 92% of you got it correct. D, last will and testament. Yes, D for dog. Number 3, a woman bought acreage in a distant county, never went to see the acreage, and did not use the ground. A man moved his mobile home onto the land and had a water well drilled and lived there for 22 years. The man may become the owner of the land if he complied with the state law regarding A lot of people give me a hard time in this question because they say it doesn't say he is the owner. It says he may become the owner. And the answer here, of which 83% of you got correct, was B, adverse possession. But it takes 30 years. I know. If he complies with the state law, he's still got 8 years to go. But if he completes it, he becomes adverse possession. So it says the man may become the owner of the land if he complies with the state law regarding adverse possession. That's correct. Number 4, which of the following is not one of the ways in which title to real estate may be transferred by involuntary alienation? Excuse me. Cafe Robusto. Get me going this afternoon. Well, maybe I missed a question or two. I'm sorry. What the state called that state does? Escheat, Akira. Gary, what if you only inherit debt? Then you got some kind of crummy relatives to do that to you. And Ayana, so that means the house would be already in your name? Missing that one. I'm not sure about that question, but let's get through these first and we'll come back if you still have questions. So number 4, which of the following is not one of the ways in which title of real estate may be transferred by involuntary alienation? The answer, of which 45% of you got, was D, season. But how can you lose property through erosion? Remember, if you're a waterfront property and the waves and the water action eat away at your property and erode the border, then you lose property through involuntary alienation. Yep. D, season, was the only one. Number 5, a person who has died leaving a valid will is called a person who has died leaving a valid will is called a testator. 76% of you are correct in answering testator, B. Number 6, a person whose land is taken for public use in New Jersey. Now, this is covered under other chapters, but it's an involuntary alienation, so you have to know the terms. A person whose land is taken for public use in New Jersey. Excuse me. And from those who answered, 59% of you correctly answered D, may challenge the money award in court. A, you do get compensated. It's called just compensation, but you can challenge it in court if you don't feel it's enough. Number 7, which of the following acquires title to real estate? Oh boy, excuse me. Which of the following acquires title to real estate? And from those who did respond, 69% of you are correct answering A, devisee. That is a person who is named as a recipient under a will. A is correct. Number 8, condemnation of private property for public use is called the right of. Excuse me. And from those who responded, 83% of you correctly answered D, eminent domain. Yes, that's the public right to take private property for a just public good, but must give just compensation, eminent domain. Number 9, the reversion of property to the state or county because of lack of heirs is called. Awesome, guys. From those who responded, 80% are correct answering C, escheat. Yes, escheat. 10, a developer passes title of subdivision roads to the town by the process known as. And about 2 out of 3, a 67% correctly answered D, dedication. Gift of private property to a public entity is a dedication. 11, an owner of real estate who was adjudged legally incompetent made a will during his stay at a nursing home. He later died and was survived by a wife and 3 children. His real estate will pass. His real estate will pass. And the answer to number 11 is, of which 47% of you got correct, is C, according to the state laws of descent. He was adjudged legally incompetent, made a will up, means the will's no good. Therefore, they have to use the law of descent to determine who gets. Number 12, voluntary transfer of property includes the process of voluntary transfer of property, includes the process of. Awesome. 92% got it correct. B, sale. Adverse possession is an involuntary transfer. Number 13, involuntary transfer includes the process of, what did I just get through talking about? Again, more people coming in the last couple minutes. Guys, we do start at 1. So if you're, longer than a half hour, it's going to hurt you. It's going to hurt you if you're longer than half an hour late to class, just so you know. Involuntary transfer includes the process of D, adverse possession, and 95% of you correctly answered that question. Good for you. 14, a man bought an apartment house as a joint tenant with his business partner. He died 10 years later, leaving a wife and 2 children. He left no will, so his widow. A man bought an apartment house as a joint tenant with his business partner. He died 10 years later, leaving a wife and 2 children. He left no will, so his wife